May it please the court, my name is Tucker Hobgood. I'm also a taxpayer of Cobb County. There are 3 separate appeals in this case, 3 separate enumerations of error, separate briefing. The court needs to consider the appeals separately, even though we're trying to put this argument in here together. I agree completely with Mr. Savage. This case is not about the Atlanta Braves. Everybody loves the Atlanta Braves. It's not about the rivalry between the city of Atlanta and Cobb County. The heart of this case, and I disagree with Mr. Savage that you have to overrule any cases in order to reverse this bond validation. The heart of this case has to do with whether the county commission was required to put it to the vote of the Cobb County voters before binding them to this long-term debt. There was no referendum here. What's more, the underlying transactions. It's not just that, Your Honor. I mean, there should have been a vote because of the debt clause, but the underlying constitutional permitted activity asserted by the county is not present here. So the sole constitutional authority asserted by the county is its power to provide for parks, recreational areas, programs, and facilities. And SunTrust Park, as it's now known, does not fit into that constitutional definition. This is a non-public professional baseball stadium. It's being turned over to private parties for their exclusive control and profit. The owners of that baseball team. County powers, this court has held, are strictly construed. If there's any reasonable doubt about the interpretation, it's against the county power. So the ordinary and natural meaning of this constitutional provision, parks, recreational areas, programs, and facilities, does not include SunTrust Park. The constitutional provision has to do with public parks, public recreational areas, the type of things that people go to on a regular basis whenever they want to, and they don't have to pay commercially priced admission. The county understands that. They have an entire parks and recreation department. Their website describes public parks and recreation centers that they operate and maintain. Silver Comic Trail, Al Bishop Softball Complex, Bells Ferry Park. The constitutional provision does not include a professional baseball stadium.
Could the county or the state, or could the county charge an admission fee? If they built the park themselves, could they charge, or any facility, a tennis facility, can they charge a rental fee?
Yes, Your Honor, this court's a good question, because this court in the Haney case in 1999, which was the city of Bremen case, it actually discusses this whole issue of when you charge for admission when it's primarily for local residents and taxpayers, and you're really actually just trying to get the cost of what it is, the user fees and things of that nature. I mean, there's a basic distinction between a public recreation and a public park and the business of entertainment, between commercial versus what's public, and the county has no power to engage in private commercial enterprise, which is what SunTrust Park is. And just so that you know, the IGA clause, which is what they're relying upon, if it's not a valid IGA, then the debt clause would prohibit it. First, the transaction with the authority is basically a sham. It's not for joint services or joint and separate uses of facilities. The authority stated they have no responsibility or obligations in the transaction. They're acting solely as a conduit for the county. Those aren't my words. That's in the minutes of the authority meeting where they approved the original memorandum of understanding in this case. It's an exhibit that we put into the record. So it's not really about intergovernmental relations. Second, as I mentioned, these services are not authorized by the Constitution. The enabling legislation, Justice Namias, does not authorize the authority to act as a bank for the county. There's one final point that I think is important. The government parties introduced no evidence other than the bond resolutions themselves and the underlying contracts and agreements. The interpretation of a contract is a question of law for the court. The proper interpretation of the constitutional provisions and their application to those contracts is also a question of law for the court. I submit there's no deference that this court owes to any of the findings of the trial court on that basis. I respectfully submit that the court should reverse the bond validation. Otherwise, we're going to have very few limits on how counties can tax and spend without obtaining the consent of the voters. I'd like to reserve any time. I know Mr. Pelfrey wants to speak for a minute.